Hi, I'm Nate Riordan with West Coast Franchise Law. One of the things that has happened in the world of franchising, as with all things, is it's gotten more sophisticated, more complicated. And as the world has moved from moms and pops with 1 and 2 stores to family enterprises with, looking to transfer generational wealth and, manage taxes as fairly as they're able, and just generally have more stores and more stuff, we're seeing people put stuff in trusts. And the thing to know is that for the longest time, even the biggest and most established franchisors had really no idea what to do about that. And they had this distinction where, how can the trust be the owner if it's not a person? And we need a person to sign the franchise agreement or guarantee it. And if it goes wrong, we don't get how to do the trust thing. And da, 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 da. And they have worked through that, are working through that. And what used to be the case was they basically turned a blind eye to it because they didn't really know how to do it, and they didn't really want to I don't know. They seemed to not want to default people for it, and so they didn't. And now what's coming is that they have rules. They're like, okay, people are doing this. We need to deal with it. We need to have rules. And one of the things we consistently see is we, the franchisor, need to have control over everything in the trust. And that's not a totally unreasonable thing. They don't want it. They don't want you to hide anything in there. They don't want you to. They don't want to lose control over their brand and access to the rights that exist in the context of the franchise agreement. But it's an oversimplistic solution. And when we're involved with estate planning and people are putting stuff in a trust, getting the franchisor through exceptions, it's everything that has to do with the franchise concept and not the other stuff, is sometimes a lot of work and more than you're going to want to do. It's just easier if you put all of that stuff into a subtrust or a separate trust. So, the vacation home, your sale leasebacks that you just have, or excuse me, your investment in other real estate, maybe you've got residential real estate like apartment buildings or something, and you just have that as your family's separate asset. Keep it separate. It's so much easier to manage the franchisor when each concept has its own little box that it's in. So if I had a client with separate concepts, I would have a subtrust for each concept. And if you work with your estate planning attorney, that should work. It'll roll up and it'll still be one set of accounting, one set of books for the trust, and it should be just one return. But it satisfies, in a simple way, the franchisors need to have separation of the franchise assets. It just cuts down on your fees, headaches, and it really, that's all your usual benefit. In the instance where there's some kind of problem that comes up and your stuff is just by itself in a subtrust or separate trust, it's so much easier. We don't need to get into that because probably not going to happen, but take it from someone who's dealt with it. If your stuff is segregated, way better. But from a low-hanging fruit, cost-saving standpoint, the less we're talking to the franchisor about what else is in the trust and digging into your private life and hey, we're not going to talk about that, the better. Put in a subtrust. Thanks.